talk about first why you decided to sit down and talk about the Taylor case in the grand jury proceeding in the first place. You've been hesitant to do that.
Well, look, we have honored, obviously, and recognized the customary role of the grand jury and that those proceedings are secret. Tomorrow, most of the recordings related to that grand jury proceeding will be made public. So I think it's appropriate now for us to be able to share details as it relates to that grand jury proceeding. Again, these are secret proceedings. That has been recognized for as long as any of us can remember. But it's now appropriate for us to talk about it, given the fact that these recordings will be made public tomorrow.
Let's talk about that. The judge ordered the release. You're going to do that tomorrow. But you have said you're concerned that this could jeopardize the federal investigation. Given that, why are you releasing this? Why are you not fighting this order?
Well, look, we're going to abide by the judge's order. We recognize the public's interest in this case, but there is some concern that this will compromise the FBI investigation. Obviously, I will defer to them on any specifics as it relates to that. But again, from the beginning of time, grand jury proceedings have been held in confidence so that questions can be asked, responses to those questions, witnesses provided during the grand jury process. What our concern institutionally was that this might ultimately chill future grand jury proceedings. We don't want that. I certainly, again, recognize the public interest in this case, and so we're going to abide by the court's requirement that we make these recordings public. But again, we certainly don't want to do anything that's going to hamper the FBI investigation, but we'll defer to them on that front.
Before we dive into the grand jury proceeding, let's talk about the fact that one of the grand jurors has filed a lawsuit. I want to read part of what this grand juror has said from the document. It says, quote, "You are using the grand jurors as a shield to deflect accountability and responsibility for these decisions." What say you about that charge from one of the grand jurors who heard the case?
Well, look, a grand juror is certainly entitled to say whatever they want to, but we were recognizing the fact that grand jury proceedings are secret. The grand jury is an independent body, but I'm not afraid of any judgments or recommendations that we made as it relates to this office. We presented all of the facts that we uncovered in this investigation. The fact of the matter is we're confident in the presentation that we put forth. Whether this grand jury speaks out or not, that's of their own accord and own volition. I don't have anything to do with that specifically. We're very confident in the presentation that we put forward. Weren't hiding in any way as it relates to accountability. Again, we were just simply honoring the tradition of keeping the confidentiality of grand jury proceedings. Now that that information is going to be made public, we're happy to discuss, and I'm obviously happy to talk about the details.
Are you concerned that this procedure, this process, how public it's been, how intense it has been, will, as this lawsuit says, put a chill on future grand jurors and jeopardize the process in the future?
Well, I think the fact that grand jury proceedings are confidential is to avoid chilling any conversations or discussions that are had during the grand jury. So the fact that these proceedings could be made public and that it could set precedent for making public subsequent grand jury proceedings could have a chilling effect. That was, again, our concern as we see it as it relates to the release of this information. But ultimately, we are going to comply with the court's order and requirement that we produce the recordings here.
Any concern on your part about what the public may hear from these recordings?
No, we're fully confident in the presentation that we put forward. At the end of the day, it was our responsibility to uncover the truth. I know the truth sometimes will make people uncomfortable. Some in the public had already made a determination about where they wanted to see this case conclude without all of the facts. It was this office's responsibility to find those facts and then have that lead to the conclusions as it relates to the grand jury process. We obviously went in again with the responsibility of providing that information. We did so. We made judgments as it relates to what was ultimately the responsible indictment to put forth in front of the grand jury. And I am fully confident in the process that we undertook and all of the information that we provided the grand jury. Look, I will remind you, this wasn't a quick grand jury. This was 2.5 days for them to hear from witnesses, hear testimony from folks involved in this case, and also for them to be able to answer or provide questions, ask questions. So I feel very confident in the process that was undertaken here.
Let's get into the grand jury presentation. Questions have been raised about who shot Officer Mattingly in the leg. The state police test essentially was inconclusive. But in your presentation, you are convinced that the shot came from Kenneth Walker's gun. Why are you so convinced about that?
Well, look, at the end of the day, let me talk about a few things that led us to that judgment, to that conclusion. First, Kenny Walker has stated that he fired the first shot. He also admits that he has a 9mm handgun. The rounds in that handgun, according to Mr. Walker, are Remington rounds. And in addition to that, the entry wound for Sergeant Mattingly was to the front of his leg. And the KSP and LMPD, the bullet that was found outside in the foyer was a Remington round. So everything indicates that that was a round that was fired by Kenny Walker. This notion that somehow there was a friendly fire or crossfire that hit Sergeant Mattingly is a silly idea. The fact of the matter is to believe that idea is to suggest that somehow bullets that were fired from outside of the apartment down the side of the apartment unit somehow made a sharp turn left to hit Mattingly in order to match up with the entry wound or the entry point of the wound to Sergeant Mattingly. But for this idea being brought into the public conversation 3 weeks ago, it was generally thought by everyone that Kenneth Walker fired the shot. Look, I'm not here in any way to make any judgments about Kenny Walker firing that shot. But what I'm here to say is that all the evidence suggests that Kenny Walker's bullet is the one that traveled through Sergeant Mattingly's leg. And the other thing that I'll make note of is that if what others are saying as it relates to the shot fired by Kenny Walker, assuming that what he said is that it's a warning shot and that the warning shot did not hit Sergeant Mattingly, then where is that bullet? Where is the hole in the apartment unit? Where is the hole in the floor? Where's the holes in the wall to suggest that that bullet traveled and hit something else other than Sergeant Mattingly in the leg?
Of course, Mr. Walker's attorney is raising the issue of Detective Hankerson also having a 9mm pistol. Did you account for that?
Well, what we accounted for is the fact that if you look at the trajectory, if you take into account the fact that Sergeant Hankinson, or Detective Hankinson, and I don't want to get too specific as it relates to Detective Hankinson because there is an ongoing prosecution, but if you take that he was standing outside the apartment and shooting into the apartment on the side of the apartment, again, it's strange credulity to think that there was somehow that bullet could have made a turn left and to hit Sergeant Mattingly in the leg. Again, up until 3 weeks ago, this was something that was not even considered or thought of until Mr. Romines made this statement during a press conference. We believe, and everything suggests, that Mr. Walker's shot that he fired hit Mr. Mattingly in the leg.
We'll talk more about Mr. Hankerson in a second. In your grand jury presentation, did you recommend any charges at all against either Mattingly or Cosgrove in the shooting of Breonna Taylor?
Well, basically, your question is about whether we recommended any murder charges against Cosgrove and Mattingly, and the answer is no. Ultimately, our judgment is that the charge that we could prove at trial beyond a reasonable doubt was for wanton endangerment against Mr. Hankinson. Miles Cosgrove and Jonathan Mattingly were fired upon by Mr. Walker. They were justified in returning fire in self-defense. So it was our responsibility, again, to present all the information to the grand jury, but it was our judgment that it was not a case that could go forward as it relates to Sergeant Mattingly and Miles Cosgrove. Because they were fired upon, they returned fire. I think that's been lost a lot in this conversation. They were justified. The tragedy here, and let me just say this again from the outset, the tragedy here is that Breonna Taylor was in that hallway with Mr. Walker and was hit and died. I don't want to at all discount or lose sight of the fact that this was a tragedy, and it pains me. Again, I had to sit in a room with Ms. Palmer and tell her about the findings or the indictment that was rendered from this grand jury proceeding. And I know that they have a lot of grief still, and that there will be grief across the Louisville community. But at the end of the day, our responsibility in the AG's office is to the truth and to the facts. I cannot fashion the facts in such a way to meet a narrative that in many ways had already been put out there before the facts had been put out there. Again, Sergeant Mattingly and Detective Cosgrove were justified. Therefore, it would not have been appropriate for us to recommend any sort of murder charges against them.
Even a lesser charge, such as wanton endangerment or anything like that, not possible because Mr. Walker fired first?
Mr. Walker fired on the officer, and they returned fire. It was justified in doing so. Therefore, it would have been inappropriate for us. Again, we have ethical obligations and considerations as prosecutors. That's regardless of whether you're in this seat or whether you're a Commonwealth's attorney. That is the responsibility that we have. We abide by those responsibilities. At the end of the day, our responsibility is to the law and to these obligations. Therefore, we thought what was appropriate was the wanton endangerment charge against Mr. Hankinson.
Wanton endangerment charges were filed against Detective Hankinson for firing into the apartment next door. Why not for the shots fired into Breonna Taylor's apartment? Why were not charges filed for those gunshots?
Well, at the the question is about related to Ms. Taylor, and the reports that we have seen related to her passing is that she passed pretty quickly. But outside of that, I don't want to speak too specifically about Sergeant Hankinson or Detective Hankinson, because there is this ongoing prosecution into him, and it would be inappropriate for me to speak too specifically about anything related to him.
And there are also shots fired into, I think, an apartment above him, upstairs apartment. Same question, why not charges in that particular case?
Well, putting aside Detective Hankinson, the trajectory suggests that those shots were fired that went through the ceiling, through the roof, from the doorway, which means either Cosgrove or Mattingly. As I noted earlier, they were justified in returning fire. Again, there is tragedy related to this, and the notion that somehow we would not have charged wanton endangerment because the residents upstairs were black is just is unbelievably absurd. At the end of the day, our responsibility is to the law and to the facts. Miles Cosgrove and Mattingly were justified. The race of the particular occupants of those units did not have any bearing on our decision making.
So help me understand, are you saying that there's no evidence that any shots that Officer Hankson fired went into the upstairs apartment? Is that what you're saying?
Yes, based on, again, and not wanting to speak too specifically about Sergeant Hankinson, there's nothing to suggest that any of the bullets that he fired traveled through or through the ceiling or roof into the upstairs unit.
You said in your news conference that the FBI ballistics test concluded that the fatal shot came from Officer Cosgrove's gun. Explain how that was determined.
Well, both the FBI and Kentucky State Police are well regarded. They both undertook analysis as it relates to the bullets that were fired by Mattingly and Cosgrove. KSP was not able to make any sort of determination as to who fired the fatal shot. The FBI, using essentially the same tests and equipment, there was nothing different in the objective tests that were conducted. Instead, they ultimately just made it a subjective determination that Miles Cosgrove fired the fatal shot. Again, putting aside the justification of Miles Cosgrove and Sergeant Mattingly in returning fire, the fact that there is that discrepancy would also make it incredibly difficult to move forward with any sort of murder charges because you're not able to pinpoint who fired the fatal shot because of that discrepancy. Defense attorneys would obviously bring that up as an issue at a potential trial. And so, again, beyond the justification for them returning fire, this other issue as it relates to those discrepancies or the conflict in those reports would make it challenging as well.
You spoke about the conflict in the reports. There are some people not trusting those reports because, for example, the KSP report said it was not definitive that the shot that hit Officer Walker, Officer Mattingly, came from Walker's gun. Talk about those two discrepancies and why you are convinced, again, explaining the trajectory and all that, why are you convinced that that was the case and why the KSP could not determine that?
Well, let me just walk back through again. So Kenny Walker admits that he has a 9mm handgun. He admits that he has Remington rounds in that handgun. The other thing I think I failed to point to earlier is the casing that was found in the hallway that evening in that direction, meaning in the hallway going out towards the door where Mattingly and Cosgrove were. That round, the cartridge that was found was from a Remington bullet. The other thing is that the bullet, and I didn't mention this earlier, the biological material that was found on that bullet outside in the foyer behind Mattingly had biological material on it. Everything suggests and indicates that the bullet that was fired that hit Jonathan Mattingly was from the weapon that Mr. Walker fired. Again, I'm not expressing any opinion either way as it relates to any decisions that are being made by the Commonwealth's attorney in the investigation there or even the civil suit related to Mr. Walker. All I am saying is that the evidence, everything indicates that he fired, he says he fired, but that the bullet that he fired hit Jonathan Mattingly in the leg.
About the no-knock warrant, you told the grand jury that a witness testified that he heard police identify themselves before entering that apartment. We're hearing reports that this person may have changed his story over time. And what about other people in the apartment who said they did not hear officers identify themselves? How do you reconcile that, and what did you present to the grand jury?
Well, as it relates to that specific witness, we presented on all of the discrepancies in his testimony. We provided all of that information to the grand jury for them to hear and to process. The fact of the matter is that particular witness was in closest proximity as it relates to hearing and being able to hear the knocking of the officers. And at least one account, on one account, he says that he heard the knocking. The fact that others did not hear that, I won't pass judgment on that. I think it's important to note that Mr. Walker said that he heard a noise as it relates to the officers on the outside. He didn't know, at least he says he doesn't know specifically that they were officers, but he is aware that there was knocking outside of the apartment unit. And so we, again, presented all of that information as it relates to this witness who was closest to the apartment, to the grand jury. That was our responsibility to do so, for them to process and understand. But the reason that I made that statement during the press conference is the fact that very early on it was suggested that this no-knock warrant was the main issue. It was our judgment, irrelevant of whether it was a no-knock or whether they actually knocked. That doesn't have any bearing on whether Miles Cosgrove and Jonathan Mattingly were justified in returning fire after Kenneth Walker fired his weapon, discharged his weapon. We simply wanted to put to bed the notion that this was executed as a no-knock warrant. Again, they knocked. The officers say that they knocked. This is corroborated, at least in one instance, by a witness who said they knocked. Again, Kenny Walker says in one of his interviews that there was noise outside the apartment that they heard. And so there is nothing to suggest that they did not knock and announce in terms of the things that were said by this particular witness and the statements that were made by the officers. But putting even that aside, whether they knocked or didn't knock does not have any bearing on the justification of Miles Cosgrove and Jonathan Mattingly to return fire.
Two questions from that. When they knocked, did they identify themselves as LMPD? It's one thing to knock, another thing to say, we're police. Are you convinced that they did that?
What we have, based on the investigation and the interviews that were conducted, this witness says on one occasion that they did announce themselves. And so we provided all of that information to the grand jury, but at the end of the day, it really is irrelevant to the determination as it relates to whether Officer Mattingly and Miles Cosgrove were justified in returning fire after they were fired upon.
But it does relate to Walker's motive for opening fire if he thought someone was entering the apartment and didn't know it was police.
And I don't take any position on his firing a warning shot or firing and hitting one of the officers. That's for others to make judgments there. I think somebody said recently, maybe Tom Wine said that, perhaps part of the tragedy here is that there perhaps wasn't criminal conduct on either side of the door, meaning where Cosgrove and Mattingly were, and what Walker did that evening as well.
You did present to the grand jury the discrepancies in this man's story and the fact that others did not hear the announcement.
We certainly provided the information as it relates to the witness and the discrepancies in his story.
Did you lead the grand jury to a particular conclusion, or did you just give them the information and they come to their own conclusion?
We gave all the information, provided all the facts related, but as it relates to the specifics of a recommendation, it was, in our judgment, appropriate to put forth for their consideration the idea of a charge of wanton endangerment as it relates to Officer Hankinson. That's the charge that we found appropriate based on all the facts. Again, the idea of presenting to the grand jury for their consideration a murder charge was not appropriate, again, because of our ethical responsibilities as prosecutors, but also because of the fact of as it relates to the justification of Cosgrove and Mattingly returning fire after having been fired upon. So it would not have been appropriate for us to present for their consideration to vote upon. If we wanted to hide, we wouldn't have even presented information related to their conduct that evening. We could have very simply just gone in, presented on wanton endangerment, and then left that for consideration. That would have been a much shorter process. It wouldn't have been 2.5 days. But it was our responsibility, in my judgment, to make sure that they got all the information. But at the end of the day, we found it appropriate only to put forth for their vote a charge on wanton endangerment against Hankinson.
So they did not have the option of considering a murder charge in this case?
That is correct.
A couple of more questions and we'll be done. Talk about the reaction to this. You have been attacked personally. You've heard some of the comments from Tamika Mallory, for example, calling you a sellout, a coward, etc. How do you respond to attacks like that?
Well, look, they've obviously put their statements out there as it relates to how they feel. Some of these folks, they seek to divide and push hatred and to stir the pot. But my response has to do with how I see people, and I hope to respond in love and in kindness. That is what, from a biblical perspective, I think is my responsibility when I have conversations in the public. And so you will never hear me raise a crossword or say a crossword about any person, because at the end of the day, I believe all of us are children of God. And so whatever she says is, that is for her ultimately to make those statements and to put those out there. The thing that I worry about is my team here. I worry for the safety of everyone in Louisville and keeping the Louisville community together. I think it is unhelpful when these sorts of divisive and hateful comments are made. And in many ways, they help stir the pot and increase the tensions in our community. And so I think it is disappointing to hear those sorts of comments. Just because I might have a different philosophy shouldn't discredit the fact that I'm a black man and that my parents are black. Just because of the fact that we might have different philosophies shouldn't in any way discount our blackness. And it's unfortunate that some people in our society have that view, and that shades all of their conversations. And at the end of the day, my responsibility here was to the truth and to the facts. And we dispensed it with that responsibility. Again, I will go back to the grand jury proceeding. We presented all of the facts and all of the information, ultimately with the judgment being that the appropriate charge was wanton endangerment against Hankinson. But at the end of the day, the facts and the truth were what our responsibility were. And Mattingly and Cosgrove were justified in returning fire. I suppose, again, the grand jury had 2.5 days to ask questions. I suppose if they wanted to push, they're an independent body. If they wanted to make a assessment about different charges, they could have done that. But our recommendation was that Mattingly and Cosgrove were justified in their acts and their conduct, and that Officer Hankinson, at least it was appropriate at this stage to charge him with wanton endangerment.
Last question. In this case, do you believe that the death of Breonna Taylor resulted in justice?
I'm sorry, say that again.
Do you believe that the death of Breonna Taylor, the result that is coming from that result of that as justice? That's what people in the streets are calling for, justice. Was justice done in this case?
Well, again, I've said from the beginning that that this is a tragedy, and there is nothing that I can do or say to take away from that fact. Ms. Taylor lost her life in the early morning hours of March 13th, and by all accounts, she was a loyal friend, a loyal family member, someone who I've been told, was the glue of the family. And I can't imagine the pain and hurt that Ms. Palmer and other members of her family are feeling, and that the community feels. I feel that pain. But my responsibility as the prosecutor in this case was to uncover all the facts and to have that lead to the conclusions, as opposed to the other way around, meaning have a conclusion and then work from that conclusion to find facts to meet that conclusion. It is disheartening in many ways that this is the result because of the tragedy. And I know that nothing I say or do will ever take away from the fact that this is a tragedy. I'm hoping what will come out of this is that we will continue to look at helpful reforms to our law enforcement systems. I've already talked about putting forth a task force to review warrants, because I think it's appropriate as the chief law enforcement officer here in the Commonwealth that I be a part of that conversation, and that we have that conversation periodically. But at the end of the day, as it relates to the specifics of this case, I had a responsibility, and that responsibility is to the law and to the truth. And we provided and presented all the information to the grand jury, but at the end of the day, the recommendation was for wanton endangerment against Hankinson, because Cosgrove and Mattingly were justified in returning fire. I know that is not the popular decision to make, but it was the right decision. And truth has to mean something in our society, and so that was what our responsibility was, and we dispensed with that responsibility.
You said yourself, criminal law sometimes is not an adequate response to tragedy. Is that what you're talking about here?
That's exactly right. I mean, there is, there are moments, and this is one, where the criminal law is not adequate to meet the tragedy, and that's certainly the case. The loss of Ms. Taylor is something that will have lasting impact. And that is something that our community is going to have to live with, and that our law enforcement community is going to have to live with. No one, again, doesn't realize the tragedy here, but that also does not give us a license to make charges that are not founded on the law and the facts. And in this role as the chief law enforcement officer, we have to be responsible to the truth, and that's what we did in the grand jury proceedings.